All right, welcome everyone. It's 12 o'clock, so we're going to go ahead and get started. As you may have heard the announcement, this Zoom record is being recorded. So it will be available at a later time should you wish to view the CLE again in the future. Okay, so you all are here for the Using Florida's New Public-Private Partnership Laws to Promote Progress CLE. The CLE is hosted by the Administrative Law Section of the Florida Bar. My name is Julia Lamonaco. I am your moderator today. For future reference, the course number is 8821, and this CLE is good for 1 general credit hour. It also counts towards 1 certification credit for city, county, and local government law. And again, it is being recorded. It will be available at a future time. So I'm going to go ahead and get started introducing our wonderful speakers. First, we have John Fermero. John has been practicing for over 35 years. He's provided legal counsel to public and private sector clients. He practices mostly in environmental, water, real estate, local government, and land use law. He litigates both in administrative, state, and federal courts. He's board certified as a specialist in state and federal government and administrative practice, and he's an AV preeminent rated lawyer by Martindale-Hubbell. He formerly served the United States Justice Department in Environmental and Natural Resources Division, and he also served as the General Counsel for the South Florida Water Management District. He focuses on federal, state, and local environmental permitting, public-private partnerships, agency enforcement, project development, agency rulemaking, environmental remediation. He's a well-known name in this area of law. He represents clients on all kinds of projects, and he's one of the authors of the Florida's Public-Private Partnership Act, which passed in 2013. So John, welcome. Thank you so much for taking time out of your day to educate us on this very important legislation. I also want to give a big welcome to my boss, Mary Cruz Fincher. Mary Cruz is the General Counsel for the South Florida Water Management District. She began her career in public service in 2008. She was working for the Attorney General's office in Tallahassee, litigating administrative, county, state, and federal courts. She also served as an attorney for the Florida Department of Revenue. She provided counsel to clients on taxation matters and supervising litigation. She joined the South Florida Water Management District back in 2016, where she practiced in the litigation section of the Office of Counsel, focusing primarily on defending permit challenges at the Division of Administrative Hearings. In 2018, she sadly left us and moved to Tennessee, where she served as counsel for the city of Franklin, Tennessee, providing legal counsel and representation to the city's commissions and departments in various areas. She rejoined the district in June of 2022 as acting managing attorney for the Everglades and Environmental Law section, and she became the general counsel for the district in February of 2023. She has over 15 years of legal experience representing both local and state government entities. So we have 2 very, very renowned speakers, very well-known names. They know a lot about this legislation, and I'm really excited to get into it. So just an overview of the topics we're going to go over today. So we're going to talk about what is an unsolicited proposal. We're going to give a little overview of the PPP Act, or the 3P Act, which is Chapter 2506.5 in the Florida statutes. We're going to have a little bit of an overview of the legislative changes from 2024 and some case study, particularly some successful 3P projects. And also we're going to hear about South Florida Water Management District's specific process for submitting an unsolicited proposal under the 3P statute, how to do it, and a detailed overview of what to expect when you submit one. And then if we have some time, I will do a little bit of a moderated Q&A to ask some great questions of our speakers. And if we have even more time, maybe I'll be able to take some questions from the audience. So we're going to go ahead and get started. Mr. Fermero, will you please share your screen and start your presentation?
Yep. Thank you, Julia. And everyone, welcome. I'm going to put up my PowerPoint there. Can you see it, Julia?
Yes, I can see it.
Fantastic. I think we have a great turnout today, and what I'm going to do is provide you with a quick overview of Florida's public-private partnership legislation, which is the statutory framework by which this is done. And just by way of introduction, I was very lucky enough to be at the right place at the right time when a legislator reached out to me and heard about public-private partnerships in other states. And I had the opportunity to work with her, Representative Trudy Williams, by the way, a former chairperson of the South Florida Water Management District Governing Board while she was in the legislature. This legislation is patterned off of the Commonwealth of Virginia. They have a P3 statute that focuses almost exclusively on educational facilities. This legislation, as I said, is patterned after that. And I'm going to just provide a quick overview. Okay, this is progressing. Let me see here. Okay, there we go. And, the first thing when you look at any legislation is what is the legislative intent? And as many of you have been hearing for years now at the federal and local level is the U.S. is experiencing problems with aging infrastructure. And one of the biggest entities that spends money in the area of construction projects is the public sector. However, the public sector is burdened by a number of laws that govern how products, services, and projects are procured. And as you'll see by looking at this slide, the legislative intent was really to streamline the procurement process under certain circumstances for public infrastructure. So what is a P3? A P3 is simply a contract involving a governmental entity. And we're having a lot of background noise. If you want to, just go on mute, please.
Give me a little agenda.
So
there's not even backup documentation for.
Yeah, would everyone please go on mute? We can hear you speaking.
Past two have been canceled because you kind of. Okay. At the last minute, always.
Ben, can I ask you to mute all of the participants, please, from your end as the host of the CLE? Thank you.
Great, thank you. So, as I said, a P3 is just nothing more than a contract between a public entity and a consortium of private entities. Now, under the legislation, a public entity is known as a responsible public entity, or as you'll see in these slides, I'm going to call them RPE. An RPE is can be a local government, can be a water management district, can be a state agency, or a special taxing district. There are two contractual vehicles for this. One is an interim agreement, which is just as it sounds. It's really to do some initial project planning, design, development, and assessments. The second statutory vehicle for an agreement is called a comprehensive agreement. And as indicated, it's really the A to Z, everything from design and planning to permitting, construction, operation, and management. The key factor in a P3 is allocation of risk. And if done properly, a P3 really involves the private sector taking on much of the risk that is traditionally associated with undertaking a project. And I'm at the end of this presentation, I'm going to very quickly touch on one case study involving Fort Lauderdale and its 5-ash water treatment plant, which is really, to me, a model P3 project. First, let's talk about how the statute defines project. It's very global. As you can see here, almost any project that involves a public service or a public function is encompassed by the definition of qualifying project. So you see here, it ranges anything from pipelines to buildings, educational facilities. It's really almost any type of public purpose project can fall within this definition. Now, this is really one of the key crossroads in the legislation, and that is solicited versus unsolicited proposals. Mara Cruz is going to talk to you about unsolicited proposals and the way her agency handles it. But right now, the legislation passed in 2013. The first bill was filed in 2010. It took a few years for it to get legs, and it passed in 2013. We really didn't see much activity, frankly, for the first 6 or 7 years. What we have seen, however, in the last few years is really a huge uptick in public-private partnership activity, and not just in Florida, but frankly, throughout the US. If you look back, you'll see that public-private partnerships in Europe, South America, have been the standard by which public infrastructure is contracted and constructed. It's been used for 50 plus years. It's relatively new in the United States, but is a very proven approach in Europe. In Europe, many of the public infrastructure, like water or wastewater facilities, are actually privately owned and operated. One of the largest P3 firms in the world is called Veolia. Veolia Water is the largest private operator of utilities, and it's a global concern, and they have significant footprint in Florida. They operate a desal plant serving the Tampa Bay area and have been doing that for several decades. Now, solicited proposal essentially means a local government says, okay, we need to construct a government building or a water plant, and we're going to put out something like an RFP or an RFQ. The difference is that under the P3 umbrella, it's really a one-step turnkey approach. Typically, if you want to, again, use the example of a wastewater plant, first, the local government says, well, we need to design the plant. So they draft a request for proposals, put it out in the solicitation, and they eventually go through a multi-month process and hire a design firm. That design firm comes up with specific plans and specifications for the plant. Then they look at that and say, okay, this is good. They take those plans and specifications and do yet another RFP to get a general contractor or a construction firm. In some cases, they want to finance it, so they have to do a separate RFP to get a financial services firm to help them with bonding or other things. So as you can see, there's several steps involved. With a P3, it's all done in one: design, build, operate, maintain, and finance configuration. And you don't have to do it all that way, but you can if you wish. Now, what we've really seen as a practical matter is tremendous growth in unsolicited proposals. Now, under unsolicited proposal, you can have an entity that says, I know that the Volusia County School Board or the Tampa Bay Water Authority needs a project. We've read a report there, they need a desal facility, or a county school board needs a new school. And entity can know about that, can get some of the documents and say, I can design and permit and construct and even operate such a project for you, governmental entity. They submit a proposal. That's called an unsolicited proposal. And under the law, if an unsolicited proposal is received, and in fact, if the government entity says, yeah, we do need this facility, there is a public need for this facility, they can engage in the unsolicited P3 process, whereby number one, they can charge an application fee to review this. And under the application fee, they can charge $25,000 or more to hire professionals to assist in the review of the proposal. Also, under an unsolicited proposal, the local government must put out a public notice saying, okay, we have received a proposal for a wastewater treatment plant They put out the public notice. They have to provide a minimum of 20 days or up no more than 120 days within which competing proposals can be considered. Now, there's been a recent update to the P3 legislation, and that happened this year in the session, where unsolicited proposal section of the P3 statute was amended so that a responsible public entity, an RPE, does not need to go through a competitive process. In other words, if they receive an unsolicited proposal and it does involve an unmet public need for a particular type of facility, they can dispense with the public notice to receive competing proposals if they jump through a few hoops. Those hoops involve conducting publicly noticed meetings where the unsolicited proposal is discussed. And here are the factors that are in the 2024 legislation for this streamlined proposal where you do not have to consider other project proposals. Number one, the benefit to the public. And by the way, all of these factors by law must be fully addressed during the course of the 2 public meetings that are required by the legislation. Also, financial structure and economic efficiencies, qualifications of the entities, and the compatibility with regional infrastructure. And that's really another way of saying, is there a need out there? Are there already governmental findings or reports that identify an infrastructure need that is unmet? And the final component is public meetings. As indicated in the prior slide, you've got to conduct at least 2 publicly noticed meetings if the responsible public entity receives an unsolicited proposal, is interested in pursuing that proposal, but does not want or does not see the need to consider competing proposals from other entities. One thing that's also, I think, been a huge catalyst in public-private partnerships, I'm just giving you 2 examples here. One is Florida Tax Watch. As many of you know, Florida Tax Watch is a nonpartisan group. I've been serving on the board of trustees of Florida Tax Watch for almost 11 years now, and Tax Watch got a hold of public-private partnership, this issue, and issued a report. If anyone is interested in this, I urge you to Google the report, and you can download it for free, but they do a very detailed study of why in Florida there is a huge need to accelerate consideration of public-private partnerships. As you see here, the numbers are daunting. The report projects a gap in Florida's infrastructure needs over the next 10 years of $2.59 trillion. The report makes a series of recommendations as to how Florida can really jumpstart the P3 process. One of those recommendations involves creating an Office of Infrastructure Investment in the governor's office and creating something akin to a P3 czar in Florida who reports to the governor. This office would be, among other things, if this is adopted by the legislature, would be creating a task force that would assess the P3 needs and opportunities in Florida and file a report with the legislature. If you know anything about Florida Tax Watch, you know they work very closely with the legislature. It's very likely that in 2025 we may see some legislation that takes up some of the recommendations in this report. And also, I think many of you have heard that the Association of Civil Engineers every other year puts out a USA public infrastructure report. And they have a number of categories. You see here at the bottom, the lower right-hand corner of the slide, from aviation to roads, bridges, drinking water, energy, wastewater, and stormwater. It's all here. And they give it a grade in terms of the condition of the infrastructure. So the grades you see here, they do a state-by-state assessment in this report. Again, it's available online. It's very interesting. As you see here, these are the grades that Florida has received. There's most of the categories are either a C or a D, which again, there is a need to update infrastructure in the US and certainly in Florida with all the growth. The question isn't if, it's how to go about doing it. And again, there are many opportunities and options here, but public-private partnerships is one of them. And I do want to talk very briefly about the city of Fort Lauderdale. In 2023, the city came to the realization that they needed to completely renovate, if not replace, the 5-ash wastewater treatment plant. That's a 70 million gallon per day wastewater treatment plant. It was built in the 1950s. It was in dire need of replacement. The city was looking at a 5 to 7 year process by which they would go through various procurement processes to replace the plant. They were looking at numbers in excess of $500 million in order to replace a 70 MGD water treatment plant. A consortium of private groups read a report that was filed in 2019 that identified the need, identified what needed to be done to meet this wastewater treatment plant that was in dire need of replacement. And in December of 2020, a consortium of companies, these including engineering, design, and infrastructure investment firm, created a coalition and submitted a P3 proposal to the city of Fort Lauderdale. This was an unsolicited proposal. Under Florida law at that time, under the P3 statute, the city was obligated to go out and publish notice that had received this proposal and see if there were any other entities or consortiums interested in submitting a competing proposal to construct and replace the 70 MGD wastewater treatment plant. And they actually received 3 proposals. The city reviewed these proposals. They ultimately selected the proposal from a group that was headed by IDE Investment and Ridgewood. But again, it was a consortium of a half dozen firms, including engineering and design firms. And that firm pledged to design and construct a 50 million gallon per day drinking water facility within 42 months. They had previously projected it would take 60 months within which to build this project. And as part of this proposal, very interesting, the consortium offered to actually operate, man, and maintain this facility for 30 years once it was constructed. In this P3 proposal, and I mentioned at the very beginning about risk allocation, the consortium committed to a fixed cost of $485 million. That shielded the city from the uncertainty associated with cost escalations. We all know since COVID that has been dramatic. And in this proposal, the consortium offered to hire all of the city's employees that were working at the old plant and make them employees of this new entity so that they would operate it. So they hired 40 city employees to work at the new facility. The city agreed to finance 75% of the initial capital expenditures. The private partners provided the remaining 25%. So that project, as we speak, is being constructed. You know, in my mind, this is a great example of P3. And if we have some additional time, I will talk about some other case studies that are underway in Florida. Julie, am I at my time limit? You're on mute.
Can you hear me?
Yeah.
You have 1 minute left.
Okay, just very quickly, another thing for those of you who are involved in land development and environmental law, the legislation passed again in the 2024 session where they created legislation that incentivized private wetland mitigation bankers to do wetland mitigation banks on public lands. So currently there are hundreds of thousands of acres owned by special districts, cities, and counties that are undermanaged and underfunded for environmental restoration and enhancement. And the legislation, again, encourages private entities to construct these wetland mitigation banks on public lands. Heretofore, that was prohibited. So we envision a great deal of public-private partnership activity in this particular arena as well, in the wetland mitigation banking arena. And I don't want to go over my time, so Julia, thank you so much, and I will stand down and let the next speaker come up.
Thank you so much, Don. That was incredibly informative, and it's great to hear from somebody who took part in writing that legislation. So thank you. Thank you for your time. Obviously stick around because hopefully we'll have plenty of time for Q&A. We're going to go now to Mary Cruz Fincher. Mary Cruz, thank you again for taking time out of your day. I am very personally aware of how busy your schedule is, so I really appreciate it. If you're ready to go, we'd love to hear about the district's 3P process.
Thank you, Julia, and good afternoon, everyone. I'm happy to be here today and talk to you about the district's unsolicited proposals process. I'm going to go ahead and share my screen. So I'll go ahead and manage expectations. As you can imagine, talking about a proposals process doesn't really lend itself to a very exciting slideshow, but I did add here some pictures of some current public-private partnerships that the district does have with external parties. And most of these projects are actually water storage projects. So you'll see the picture of the project, and then you'll see a little caption with the name of the project. So with that, I'll start with the process itself. So step one, which is you have a project that you think the district will be interested in. So you create a project proposal that meets the definition of a qualifying project under the statute. And when you're creating this project proposal, this is your chance to do a 1 to 2 pager. Tell us what your project's about, why you think it meets this definition, and why the district is the entity to partner with. Note that this is just the initial proposal, which will be posted on the district's procurement site and considered a public record. So at this point, you don't want to include information on your proposal that could be detrimental to competition, right? So you don't want to include things like design details or costs and things of that nature. This is a very high level project proposal that you submit to the district. So that's step one. Step two, so you submit the proposal. We need both a hard copy and an electronic version, and you can either mail it to this address or hand deliver it to our building, B1, at the South Florida Water Management District. There is a $1,000 initial application fee, and that must be by cashier's check or cash. We don't accept personal checks. If throughout the course of this process you decide to withdraw your proposal prior to us initiating the evaluation process, you may either request that your fee be returned or that the district hold on to it for up to a year. to allow for that, for the submittal to be resubmitted or a new unsolicited proposal. Step 3. So step 3 is where the district decides whether your project has met the definition of the statute as a qualifying project. It then also determines, either at the leadership staff level or at the governing board level, whether it's going to evaluate your project. If the answer is no, then we will return your application fee. If the answer is yes, then a few things will happen. One, we'll request additional materials, and this is the opportunity for you to provide your comprehensive proposal. All of the things that I said you should omit initially, this is your opportunity to then supply that information so that we can properly evaluate your proposal. At this time, we'll also set up evaluation criteria, which is the criteria that the committee will use to evaluate your project. At this time, we'll also look at creating an evaluation fee, and that's going to be based on how much staff time it's going to take to review your proposal, the type of review, like whether we need outside consultants or things of that nature. That evaluation fee will be due 30 days after we provide you with that number. And then at this point, we'll also determine whether we're going to do additional proposals. So as John touched on in his presentation, the statute changed this past year, and it allows us, when we receive an unsolicited proposal, to decide whether or not to solicit additional projects that could have the same benefits or within the same area, or just evaluate that project as a standalone project. So at this point, during step 3, we'll make all of those decisions. Step 4, if when we received your unsolicited proposal, we decided, again, either at the staff level or at the governing board level, that we were going to compete this project idea and ask for additional proposals, we formed the evaluation and selection committee, and they score your proposals. And then we'll have a public meeting to discuss and rank the proposals. And then if there's a tie, the committee will request oral presentations. So step 4, no additional, if we don't solicit additional proposals, meaning we received your unsolicited proposal and we decided that it was unique, and it was unnecessary for us to solicit additional proposals. As John touched on his presentation, we must have 2 notice public meetings. Now, if your proposal already went to the governing board in the initial process, I believe it was in step 3, then that already counts as your first meeting. But if not, then the first meeting is a description of the project will be provided, and there's an opportunity for public comment. And then there's a second meeting, and that's where the committee discusses the evaluation of your proposal. Once that second meeting concludes, that committee is going to make a written recommendation to the specific division director. And as John touched on his presentation as well, the district must file a public interest determination report. And he went through all of the components of that report. So we'll move on to step 5. If your project is selected, it may need to go to the governing board for approval depending on the cost and type, which just is if it exceeds the delegated threshold that staff has, it will go to the governing board. Step 6. At this point, we've awarded the project, or if it was under the threshold, staff has decided to move forward, and we start negotiating a project agreement. If we had additional proposals that were awarded as well, then the district can negotiate with the private entities in that ranked order until the negotiations result in an executed project agreement. And as it says here on the slide, we may terminate the negotiations at any time at our sole discretion. So step 7 is we execute a comprehensive agreement. And I know John also talked about, some of the things that have to be in that agreement. And it's required by statute that we have things like public liability insurance, that there is a termination upon material default clause, and any other terms and conditions that the district believes will serve the public purpose of the statute. And that's it. Those are the steps we have. This guidance document QR code will take you to our website where you can find an outline of all of these steps and a description, so that if you are hoping to submit an unsolicited proposal project to the district, you can follow those steps. And that concludes my presentation.
Great. Thank you so much, Mary Cruz. As you can all see, it's a relatively straightforward process. It looks like, and the district has gone to great lengths to make it as simple as possible for folks to submit their proposals. We have plenty of time for Q&A. So I'm going to start off. I'd like to talk a little bit about the public records indications or implications of this legislation and of the district's process. So I know there's a lot of concern from folks who want to submit a proposal that they're going to submit their proposal, and if there's a solicitation process where other proposals will also be accepted, the concern is this competitive nature, that all of their information is going to be out there for somebody else to use in submitting their own proposal, and it makes the other folks have a higher advantage because they have more information. So I think you talked about it a little bit, Mary Cruz, but can you explain some of the processes the district has put in place to try to circumvent that issue of public records?
Absolutely. So as I indicated initially, when you first submit your project proposal, that's the opportunity to keep it very high level and not place any information in that proposal that could that you could lose your competitive advantage with. And so throughout the process, when the district does make the determination that it will solicit additional proposals, at that point in time, all proposals will be due at the same time. So if you submitted an unsolicited proposal and it's that, one pager, and we have decided we're going to solicit additional proposals for a project of that kind, both your comprehensive project proposal and the additional solicitors are going to be due at the same time. So your original project is not going to be out there before theirs are due to be submitted as well.
And so the current public records exemptions protect that information once there's a solicitation. So nobody can request each other's documents once they've been submitted under a competitive process.
Correct. That is also true.
Great. John, I believe you're still with us. If you want to pop your camera back on. There you are. Hi, I see you. Maybe I just didn't see you on my screen. John, coming from the private sector, do you see any other ways that agencies can protect folks who are submitting their initial proposal and are worried about the public records implications? You're on mute, John.
Sorry, yeah. So when the legislation passed, there was actually a public records exemption. Unfortunately, there was a provision in the legislation that sunsetted the public records exemption. And there has been a few failed attempts in the past to reinstate it. It is a huge stumbling block for an entity that wants to submit an unsolicited proposal. And the question is always, how much detail do I put in that initial proposal? For example, pricing, which is a key consideration. no one really wants to put pricing in the initial submittal because they will obviously be at a competitive disadvantage once the agency opens it up to other bidders. So it's a bit of an art form as to how much detail do you put in to entice the governmental entity to say, hey, this is something that makes sense. Here's an unmet need in terms of public infrastructure. So you want to put enough information in detail to gain the interest of the agency, but not so much as to put you at a disadvantage. Sometimes there could be a certain type of technology or a particular approach that's taken that can do that. So what Mayor Cruz outlined is very accurate as far as what most of my P3 clients are doing today, which is submitting an unsolicited proposal with more of a concepts. And if the agency is interested, then we can engage and they can open it up and put out a notice that, yes, we want to pursue project X. You know, in a perfect world, I would like to see that that public records exemption reinstituted. In fact, the legislation that passed in 2024, I think, is to some degree a reaction to that, where under the new 2024 amendment, if you submit an unsolicited proposal, the agency does not have to open it up to competing bids. In that scenario, you could put all your cards on the table, including pricing information. Again, from a matter of public policy, I think a lot of agencies, at least initially, may not be entertaining that because they want to be viewed as transparent and accountable in the public procurement process and want to have some level of competition. So, you know, again, this just became effective. It's been effective just a few months, so we'll see how that plays out. But I really hope that in the near future, we're going to reinstitute a limited public records exemption for an initial unsolicited proposal.
Great answer, John. Thank you. One more question for you, and you touched on it a little bit, is this change to the legislation where previously the agencies were required to publish notice when they received an unsolicited proposal and request any additional proposals from other sources. That no longer being the case, the agency now has the discretion to decide whether that is something they want to do. Do you see, from the private sector standpoint, an agency's decision to solicit being a deterrent for the private sector to do business with that agency if they know that when they submit their proposal, there's going to end up being a solicitation?
Yes. So I can give you dozens of examples from Miami-Dade County, for example, throughout Florida, frankly, where an agency, a local government, received an unsolicited proposal and they were very enticed and they realized, boy, this is something we need or something we should be doing. They've taken that unsolicited proposal and turned it into something like an RFP or an RFQ. And, you know, for those of us in the private sector, there's a great deal of time and money spent in developing these proposals. And I have to confess also a great deal of frustration when such a proposal is submitted and the agency goes back to their traditional approach. And again, this with all due respect to government, you know, government almost by definition is reluctant to try new things because there is a certain level of risk involved when you deviate from the tried and proven procurement models that are out there, namely RFPs, RFQs, requests for qualifications, ITNs. All of those have been around for decades, and I think, unfortunately, it's easy for procurement officials to just default back to that approach. We're seeing change happening. You know, the Florida Tax Watch report is a good example. There's now a spotlight that's on the legislation, and there's interest now in maybe further refining that legislation and further encouraging local governments to step outside the box and try a new project delivery methodology, which is in the end what this is all about. Project delivery. What is the most effective and efficient way to use public monies to deliver key public infrastructure projects, whether they be schools or water utility plants or buildings?
That's really good insight. Thank you. Mary Cruz, from the agency perspective, do you see a benefit to this, this newly implemented discretion for the agency to decide, is this the type of project that I want to solicit additional proposals for?
Yes, I mean, I think it's a great change to the statute because before it was required and now it's discretionary, and I think that gives the district the opportunity to evaluate a proposal, and we could easily receive a proposal that's so unique that there is no way that anybody could solicit or could propose something similar, right? Whether it be the location or the type of technology being used. I mean, I could see situations where there would be no need to solicit additional proposals. And so I think that having that as a may now in the legislation, that gives us the opportunity to be more efficient, because, why would we want to go through this competitive process if truly this one, entity is the only one that can really deliver this type of project, again, either based on the technology or the location. So I think it's a great change.
Yeah, and Julie, if I can interject, I mean, I applaud the South Florida Water Management District in developing a policy like this, because I can tell you when I was there, from all over the world, we received proposals on new water quality treatment technologies, and there's a ton of them that have just come out on the market in the last few years. I'm sure Mayor Cruz will tell you they're still receiving proposals in the context of Everglades restoration. I can make your stormwater treatment areas more effective. I have a new technology, and some of these folks don't want to reveal that that's proprietary, how the technology works. So I'm hopeful the district will be able to ramp up and even in some cases do some value engineering on stormwater treatment areas and water quality treatment in general.
Yeah, definitely. And also, I think my understanding is, and correct me if I'm wrong, not many agencies or local governments actually have a process in place for this legislation, to implement this legislation. I know the district spent a significant amount of time creating the process. And so I think Mary Cruz would join me in saying, if there's anybody on this CLE that works for an agency or is in contact with an agency that doesn't have a process and would like to understand more about the district's process, absolutely please reach out to Mary Cruz Fincher so that she can help you and your agency perhaps come up with a process as well. It is very time consuming, but it's definitely worth it to implement this legislation for efficiency and cost purposes. And our infrastructure definitely needs it.
Yeah, there's a little over a dozen, mostly cities and counties that have adopted similar P3 processes. City of Sarasota, Miami-Dade County, those are good examples of local governments that have gone further. Miami-Dade County has actually an extensive code provision on consideration of P3s. I think in the chat, you'll see someone posed a question to Mary Cruz. It's a very good question.
Now let's see here. Let me pull up the
Fred Springer.
Fred Springer. Hi, Fred. I hope you're doing well. Let me see. I'm having a hard time locating that chat.
I'll read it. It says, Mary Cruz, it sounds like the district views the unsolicited proposal process merely as a means to trigger a solicited proposal process. That is, if the district likes the one-pager idea, that is a catalyst for the district to initiate a solicited proposal process, question mark.
So, Fred, thank you for your question. I think that the way the district views this is we're going to evaluate each proposal and determine what's the most efficient thing that we can do here, right? And I don't think we see it as an opportunity like for somebody to present an idea and say, oh, now let's try and get the best, bang for our buck and see if we can compete this. I think, we're in the business of being efficient. And I think that if we received a project that was truly unique and could provide benefits to the districts within the district's jurisdiction, we wouldn't, necessarily compete it. So I think each project staff spends a lot of time reviewing and meeting and talking about it and really thinking through the proposals. So I don't necessarily see it as a way to get more competition.
And if I may, I see the 2024 legislation. If someone came to the district and they had a proprietary technology for treating phosphorus or nitrogen in the water column, and it was the scientists at the district look at it and say, we haven't seen anything like this before. They've done pilot projects. It seems to be effective. I can see the vehicle now, the more streamlined vehicle where they don't have to go out and compete because it's a unique proprietary technology. I could see that really working well for the district.
Absolutely. Okay, it is 12:51, so we only went 1 minute over our time. I am incredibly proud of that. We have such a big topic to talk about, and I know we could have talked about it for probably another hour. But I want to thank our speakers again, Mary Cruz and John. Thank you again for your time and for all of your knowledge and experience. We really appreciate it. For those of you who weren't here at the very beginning, the course number again is 8821. This CLE counts towards 1 general credit hour. It also counts towards 1 certification credit for city and local government law. And again, this was using Florida's new public-private partnership laws to promote progress. Mary Cruz Fincher and John Fermero, thank you so much. My name is Julia Lamonaco. I've been your moderator today. It's been a pleasure. Thank you for taking time over your lunch break to spend with us, and enjoy the rest of your day.
Great, thank you.